Good morning, everybody. We're just going to wait a minute or two to let everybody in. So we're just waiting a minute or two to let everybody in. Okay, let's get started. Good morning, everybody, and welcome to our webinar, Business Visitors to the UK, What Companies Need to Know About Immigration and Tax. I'm Samar Shams. I'm a partner on the Immigration and Global Mobility team at Spencer West, and I'm delighted to be joined today by Charlotte. Would you like to introduce yourself, Charlotte?
Sure. Morning, everyone. Thanks so much for joining us. It's really lovely to be here this morning with Samar. I am a senior manager in the expat tax team, which sits within Global Employer Services at BDO. And as Samar said, we're going to be talking about business visitors today, which, as we all hope, I think, is going to start, everything's going to start opening up soon. This is probably going to become a hot topic yet again.
Thanks, Charlotte. So just to tell you a bit about this webinar before we get started on the meat of it, everything that comes out of my mouth is going to be about immigration. Everything that Charlotte talks about is going to be about tax. I just want to make that clear because we're both going to be using the term business visitor or maybe short-term business visitor, but we are talking about two different regimes, the immigration regime and the tax regime. So we are going to be laying out the eligibility, et cetera, for each. And I just want to make clear that when I'm talking about business visitors, I'm talking about people in the UK and having visitor status in the UK, whereas Charlotte is talking about short-term business visitors as per the relevant tax regime. Did I say that right, Charlotte?
Sounds good.
Okay, great. So if you have something to say, we'd love to know what it is. Could you please just put everything in the chat? I'll be monitoring the chat, but I'm not going to be going into the question and answer section as well. If we could just have everything in the chat, that would be great. We have a couple of polls for you today as well. And anybody who's ever attended a webinar of mine previously will know that I would really be so pleased if you would engage as much as possible, albeit in the webinar format. We're going to run for up to 1.5 hours today. Hopefully it won't take that long, but we have given ourselves that cushion at the end for additional questions. Feel free to ask questions as we go along. So one last thing about the format, this is being recorded, so just be aware of that. Okay, so what are we going to talk about today exactly? We're going to talk about eligibility criteria for both the visas, visitor visas, and the short-term business visitor tax regime. We'll talk about tracking and documentation for each. We'll talk about people who don't meet the short-term business visitor criteria and different types of visitors under the immigration rules and visitor visas under the immigration rules. We'll also talk about consequences. And Charlotte's going to say a few words about non-resident directors in particular. And at the end, we'll discuss some things to keep in mind in relation to COVID-19 and workers who might now be working remotely or are stranded because of travel disruption. So without further ado, let's get into eligibility criteria. Charlotte, do you want to talk to us about the tax regime a bit?
Yeah, thanks, Samar. So I'm going to start to talk about what exactly is an STBV. Why would a company need it? And I think this is quite important because a lot of companies still aren't aware of this agreement with the revenue and what it's all about and why you would need one. So something important to be thinking about if you haven't got one at the moment, whether you actually need one. So what exactly is it? So a short-term business visitor to the UK is someone who is employed by an overseas entity, who's coming over to work in the UK. It could be for a day or two here, it could be for a short-term project. And what a lot of people don't know is that the default position in the UK is that when someone comes over here and is working here, even if it's for just one day, PAYE, or tax withholding, as some of us may know it as, is actually due from the first day that that individual is working in the UK. So the default is that they should be put on a payroll and PAYE should be paid over to HMRC. However, because we do have tax treaties with many countries, a tax treaty can often be used to exempt that individual from UK income tax if they are indeed resident overseas in a country that we do have a double taxation agreement with. So what you've got in practice then is a situation where a company might have to withhold PAYE up front and the individual then has to file a return to claim it back again. Well, obviously that is a very big administrative burden for both the company and the individual. So HMRC realised that this wasn't a particularly practical idea, and they came up with a practical solution, which is the short-term business visitors agreement, or otherwise known as Appendix 4. And if you sign up to this agreement as a company, then you are essentially agreeing certain terms with HMRC that then allows you a relaxation of this PAYE withholding. So essentially you don't have to withhold PAYE as long as certain conditions are met, and also you do go through certain processes. What you then have to do is you have to agree with HMRC that you're going to track your business visitors, and we will talk a little bit more about that a bit later in the webinar. And you then have to report at the end of the tax year the details of those business visitors to HMRC, and you make an annual submission of that information. I won't go into a lot of detail about what the reporting requires, but what I will say is it does vary on how long someone has been here for. So it can vary from no information at all, if they've been here for a very short amount of time, up to things like having to get an overseas residence certificate from the overseas country and submit that to HMRC, which obviously is a bit more administration and also can cost the company as well. But it is a practical solution that means that you don't then have to go through PAYE withholding. But in order to do that, you do have to have this agreement in place. It has to be signed by the company and also signed by HMRC as well. Over to Samar.
Thanks, Charlotte. That was super clear. So let's talk about visitors in terms of immigration status. So some basic eligibility points. You have to intend to leave the UK within 6 months of when you enter. And you must not be living in the UK through frequent or successive visits, and you must not make the UK your main home. Now, we're going to look at this timing element in a bit more detail later on. I'll leave it at that for now in terms of timing. Visitors must not be paid from a UK source. Okay, you can cover their travel and subsistence expenses, but other than that, they can't be paid from within the UK. And they have to have sufficient funds to maintain and accommodate themselves, so during their visit, and also to be able to leave the UK. Now, what can you do as a business visitor in the UK? So business visitors are considered to come under the standard visitor type. There's no actual business visitor route in the UK, a separate route for business visitors, but you're allowed to do general business activities in the UK as a standard visitor. I haven't listed them all here, because it's quite a long list, but I've listed the most common activities that business visitors undertake. So attending meetings, conferences, seminars, interviews are allowed. So you might have seen in the press about EEA nationals entering the UK after Brexit and being detained when they were legitimately coming for interviews. We'll talk a bit more about what they could have done to avoid that unfortunate situation, but you are allowed to come for interviews. You can come to negotiate deals and sign contracts, and you can be briefed on the requirements of a UK-based customer as long as the actual work is done outside the UK. So there are some fine lines here. In terms of intra-corporate activities, so that means employees coming from overseas and their overseas employers are part of the same corporate group, international corporate group, as the UK entity, then there are some specific activities that they can take part in, as long as it's on a specific internal project, so they can advise, consult, troubleshoot with their colleagues in the UK, share skills and share knowledge. And then there are allowances for training, but it's very specific. It cannot be on-the-job training. It has to be classroom-based, has to be based on familiarization or observation. Okay, so those are that's kind of an overview of what's permitted. Now, we could talk about work. Just trying to pull up a poll for you guys. Oops. So work and selling are prohibited. And the Home Office's definition of work is really quite broad, just be aware. It includes work either as an employee or on a self-employed basis. It includes work placements, internships. Internships are a huge issue for a lot of companies now with the closure of free movement, because there aren't a lot of visa routes otherwise for interns, but there are some. So if you're having trouble with that, do let me know. And short-term cover for a UK-based role would also be considered work. We have a question in the chat about permitted business activities. Simon has asked whether interviews for jobs are permitted. They are. A mix. Simon has also asked whether a mix of classroom and hands-on work placement would be allowed as training. No hands-on work placement training would be allowed, only classroom or observational. So that means, observational and familiarization, that basically means shadowing someone, standing over their shoulder. You're not allowed to do anything hands-on or on-the-job training. Also, selling goods and services is prohibited. So you can come and attend a trade fair, but you can't actually sell anything at the trade fair. You can only attend for promotional purposes. Equally, selling services is prohibited. So there are exceptions, but these are the general prohibitions on work. So there are some exceptions, but I would look into those specifically before bringing someone in to do anything other than the permitted activities. I hope that's clear. Let's talk about tracking and documentation.
Thanks, Samar. That leads nicely into thinking about the process that you would need to go through for an STBV agreement and the tracking as well, which is really important. So when we first think about what is the initial action needed, so if you're at the stage where you're thinking about whether you need this STBV agreement in place, it's analysing your business visitors and understanding what your obligations are. which ties in a little bit with what Samar was saying about coming to the UK for different purposes. So when we think about tax from a tax perspective with regards to the STBV, if someone is coming over for what we call incidental duties, so it would be things like training, possibly a conference, those kind of things, then they might not fall under the need for an STBV. But if someone's coming over to perform more substantive duties, that would fall under the STBV. So it's analysing whether you need one of these agreements. I would say probably in most cases companies do, because they do have individuals coming over to do actual work or projects. I won't go into too much technical detail, but there is also the analysis of whether someone is actually coming over to work for the UK company. But obviously, you know, I think it's just worth mentioning that so you can think about that when you seek out advice for putting one of these agreements in place. If you do realise that you do need one of these agreements, then you would make an application like I mentioned earlier, which you would sign and HMRC would sign. And once that application is in place, then you do need to start tracking your visitors going forwards. And I'll just talk about that in a bit more detail in a minute. Just also mention that at that point in time, you might also want to look back over prior years to identify whether there's any kind of disclosure needed for prior years if you haven't been reporting anything in prior years. And that's that point in time when you might want to consider looking back over. Usually the previous 4 years is the usual amount HMRC would expect you to go back. A bit of a caveat, that does depend on behaviour of the company and whether proper processes have been in place and whether maybe it was just an inadvertent failure or a deliberate failure. So thinking more about the tracking, there's not really a one-size-fits-all for tracking, because I think that's going to depend on how your company is set up, number of employees, how large your company is. I've had various conversations with clients about tracking, and ultimately it's got to work for you as a business. I think the important thing is that someone actually takes control and responsibility for that process, which might sound very obvious, but I think it's one of those things that can get slightly lost sometimes as to who actually is responsible for it. Some companies, we've had conversations where the person on the reception desk might actually be incredibly important in the process, and they might need to be trained up and understand exactly what this process is and why they are tracking these individuals that are coming into the company. As I mentioned before, the STBV reporting is on an annual basis, and that is done after the end of the tax year. And when the tax year is finished, you would collate all your data together and do your reporting at that point in time. But obviously you will have been tracking your individuals throughout the year. Just something to mention on the tracking, it's actually tracking of days in the UK. So if you've got an instance where someone comes to the UK on a Friday for a meeting and they end up staying in the UK for the weekend, then you do need to be tracking those days that they're staying for the weekend as well. And I know some companies do struggle with that, but that's just an important point to point out there. And from a reporting perspective, there are now a lot of very smart online technological solutions that you can use. Obviously, it's going to depend on your company and whether this is useful for you, but lots of companies are now finding that having an online tracker is really helpful. And not only does this online tracker track your business visitors, it can do all sorts of other things as well. So for example, you can do pre-approval authorizations. So someone would put in what their trip is going to be, where they're going to be going, how many days they're going to be going for, and the system will then basically kick out a report for you to tell you what your risks are. And that can be obviously really helpful from both a tax perspective and also an immigration perspective, and also a duty of care perspective as well. With COVID obviously not really going away at the moment, the system's been really useful to give people things like border closures. COVID levels, what are the rules for COVID in that particular country at that point in time. So the system can do all sorts of things. And if you've got, for example, BDO, we have a technological solution called BDO Quick Trip. And if you already have an immigration advisor, then we can link with them and it will send them the reports that they can then work on the visa requirements. So it's very easy to use and it can be used amongst a lot of different suppliers as well. The other really useful thing that companies have found with these trackers is that they now often have a remote worker risk assessment part built in as well, which I know for lots of companies, this has been a very, very big issue over the last year. Lots of companies have found that they have got not only workers in places where they know about, they shouldn't necessarily be, but they know about. So for example, people may have decided they want to return home to their family during COVID, so they've been working remotely from a different country. Lots of companies have found that they've kind of found covert remote workers, people they don't know about. So once you've got the system in place, if you've really got this fully embedded in the company, you can track those remote workers. And as soon as they get to a point where there could be a tax issue, it will start to trigger those reports, which is going to help you monitor them, basically. And then just touching on non-resident directors, which I'm going to come back to later in the webinar. Non-resident directors can be slightly different reporting requirements. They can fall under the STBV, but not always, and it does depend on the duties that they're performing in the UK. So if you, for example, have got a non-resident director of a UK company who's coming over to the UK, they might be performing global role duties, so relating to the normal job that they would do on a day-to-day basis, or they might be performing actual director duties, attending board meetings, etc. And the reporting for that is different. So I will come back to that a bit later in the webinar.
Thanks, Charlotte. So we have a few questions, and there are a couple about permitted business activities that I'll answer, but maybe you want to answer Sharad's question first. I'll read it out to you. Do we need to track all days or only work days, as we use UK work days / total work days for the calculation?
Yeah, so I think this is a question that comes up time and time again, actually. So good question. So the reason you're tracking all days is because the STBV is related to the treaty. So the STBV agreement is based on the employment income article of the tax treaty, which has this 183-day condition, but that does relate to all days in the UK. So you would be tracking also holidays as well as work days, which I know is unfortunately a bit of an administrative burden. When you're talking about the UK work days over total work days, I'm guessing there you're thinking about if you had to report the income because possibly this person doesn't fall under the STBV, which we will cover a little bit later, then you would obviously be using that kind of calculation to work out the income you're reporting. But when you're thinking about STBV and whether they have exceeded those 183 days and which categories they fall in for STBV, you will be tracking all of the days that the individual is in the UK.
Thanks, Charlotte. So I'm just going to go back to a couple of questions about permitted activities from Simon. So Simon's asking about Oracle. Oracle sends overseas staff to sell and market its services at its annual UK event and whether this is allowed. So if you were to say to the Home Office, to the Border Control Officer, when you were entering the UK as a US national, who doesn't need to apply for a visa beforehand, I'm coming to a trade fair to sell services, then you would be refused entry. So technically, selling services is not allowed. Now, if this is a question that you need advice on, I would encourage you to contact me for specific advice, because it will come down to what actually happens on the ground at the trade fair and explaining that in a letter that you might present to the Border Control Officer, which we'll talk about in the documentation section. Simon also asks about what's allowed now versus previously. So he says that he used to be a graduate trainee as a seismic data processor, and had an extensive training course in the classroom, followed by hands-on processing. And there were people from Norway and New Zealand. Now, Norway and New Zealand are two different cases. Graduate trainee is a different, there's a particular type of sponsored worker route for graduate trainees. What you're describing would be allowed to both people from Norway and New Zealand under the sponsored intra-company graduate trainee route. It would not be allowed to business visitors because of the hands-on element of the training. So I hope that's clear. And this might be a nice time, now that I've figured out how to pull up the poll, to do a little quiz for you guys before moving on, if you don't mind. We are going to do a poll about work, if you're ready. So, are you allowed to work in the UK with visitor status? Please vote. Yes, no, not officially, but actually you can. Generally no, but there are some exceptions. Just give everybody a chance to vote. All right, I'm going to close voting and share. Oh, last few votes in. Okay, I'll wait a couple of seconds. All right, I'm going to close voting now and share the results. So, who can guess my least favorite answer? So my least favorite answer is no officially, but actually you can. I hate that answer. I will actually accept any other answer, but the best answer is generally no, but there are some exceptions. And I think actually that answer necessarily encompasses yes, no, generally no. So yes is kind of the second worst answer. I would say no. If I had to answer yes or no, I would say no. So as a business visitor, really you have to stick to the permitted activities which are listed in the immigration rules. And there are some exceptions. So it's always worth just getting some advice if you have a very particular situation and having somebody look at the rules with the information about, what exactly you're trying to do, where the person will be paid from, how long they're staying, etc., what their role is, because there might be an exception that you fit into that would allow what would otherwise be considered work. But otherwise, please do stick to meetings, interviews, conferences, negotiations, being briefed, and do not work in any capacity. We'll talk about consequences later, but it really is very important. I'm going to stop sharing now. Now, Charlotte, I know you had a poll. Did you want to run that poll as well, or has
let's go ahead.
Okay, so Charlotte's going to run. I'm going to run Charlotte's poll for you guys, if you don't mind. Here we go.
Yeah, so a really easy one here. Just interesting to see, does your organization have a short-term business visitors agreement? For those of you that do, you might be sitting there thinking, well, of course, I guess if you're on this webinar, maybe you don't, because that's why you've come along. But it's quite interesting, the number of companies who aren't aware of this agreement. So yeah, let's run the poll and see. It'll be interesting to see.
Okay, we're still getting a few votes in. I'll wait a few more seconds. I wish I had more of the lingo around, closing betting and things like that, but I don't, I'm afraid. Which is probably what you want in a lawyer. Right, I think we've got all the votes we're going to get. I'm going to end polling and share the results for you to discuss. Oops, a couple more people coming in. All right, I'm ending polling now. And here are the results.
Oh, amazing. Split 50-50. So that's really quite interesting, actually, isn't it? So yeah, I guess for those of you that don't, it's worth considering, do you need one? It may well be that you do. And for those of you that do, I guess you're hopefully here to maybe learn something new that might be helpful. Great. Thank you so much, everybody, for participating in the polls. It's fun for us, and hopefully for you too. So there are a couple more, there's a couple more questions. HCCA, okay. Not sure, I think that was just for us. So let's move on. I'm going to talk a bit about the time limits as promised, relating to being in the UK as a visitor. So there's a lot of confusion over this because the UK rule is different to most other places. There is no specified maximum period within another longer period that is the limit on business visits or on visits to the UK generally. Okay, so a lot of places will have this rule where you can only stay 6 months out of every 12, right? X duration out of X duration. That is not the rule in the UK. So the rule in the UK is each time you enter, you are only allowed to stay as long as you're authorized to do. For visitors, that's usually 6 months, but there are longer term visitor allowances. For example, up to 12 months for an academic or other non-business reasons, people can stay for up to 12 months. So I hope that that is clear. You don't have to track your days in this sense with in terms of immigration, because there's no however many days out of however many months or however many months out of however many months that you're limited to, okay? It's just that each visit has to be a certain period, usually 6 months and not longer, okay? And there's this beautifully British rule. So we don't have a set number. We have a quite a flexible rule. Visitors must not be living in the UK through frequent and successive visits. Okay, that is the rule. And as you can imagine, it's lovely in a way. You don't have to worry about tracking, etc. But the Home Office can use it, to refuse entry in a fairly subjective manner. So what are they looking at? Every time you come in, they're going to look at the purpose of your visit and the intended duration of your stay. How long are you intending to stay? So for example, something that happens a lot, this isn't really a business scenario, but something that happens a lot is that the visitor's fiance or spouse or unmarried partner, long-term partner lives in the UK, and this person's coming in to visit them. And then they're going to spend, quite a few months with them. Maybe they do intend to stay less than 6 months, but maybe only just less than 6 months. If that person doesn't have a lot to go back to in their country of origin, a job where they're expected back, commitments, other very close family, etc., then that's likely to be refused. And I mentioned earlier the case of EEA nationals coming in for interviews. Well, some of those people were interviewing for jobs because they wanted to move to the UK because their partners lived here. That always raises a flag for border control. It doesn't mean you can't do it, but prepare yourself a bit, have the documentation in place. And again, we'll talk about that in a bit. So what else are they going to look at? They're going to look at the number of visits that the person's undertaking. Are they spending more time in the UK than in their home country? Now, this is where the immigration requirements are similar to tax in that they're going to look at both business and pleasure visits when they're assessing how much time you're spending in the UK versus your home country. There are no set numbers, but everything counts, if you see what I mean. And then what is the purpose of their return trips? Are they leaving the UK just so that they can come back in and restart the 6-month allowance?
Now, I'll tell you that my grandmother lived in the UK for many years when I was a child. And I remember her always having to leave every 6 months and return just to restart this. You know, those were the good old days, the 80s. You know, she wasn't much of a threat living off the King's Road in London. And may she rest in peace, she's passed away now. So perhaps finally beyond the long arms of the Home Office. But that's something that people used to do. And they are going to be looking at that quite closely now. So you can't be just leaving the UK just to re-enter and restart the 6-month process. So I hope that's clear. They'll also see whether you've had a history of refusals for other UK visas. So for example, somebody tried to apply as the partner of a British national, they were refused, and now they're coming in as a visitor right afterwards. You know, so the purpose of their previous application was to live with their partner, and now they're saying, oh no, I'm just visiting, I'm just a business visitor. You're going to need documentation to back that up. Now there's a question from Sachin. How do the rules work for UK nationals who are resident overseas and paid from a non-UK group company, but they come back to the UK for short-term business visits? So UK nationals coming into the UK, there are 0 immigration issues there, okay? Now, I just want to make clear that I'm talking about a full UK citizen, because there are all different levels of citizenship, UK citizenship, British citizenship. But if you're talking about a full UK national, then there are no immigration issues. I don't know, Sachin was maybe interested in the tax situation. Charlotte, do you want to address that?
So from a tax side, if they are employed by an overseas entity, resident in a country that we have a tax treaty with, and they come back to work here, then they would potentially be covered by the STBV if you had an STBV agreement in place. So as long as they meet the conditions of that agreement, so below 183 days, and other various conditions, then they should be able to be covered. It doesn't matter that they're a UK national. It's who they're employed by and who's bearing the cost of their employment.
Thank you. Okay, let's talk a bit about documents, as I promised. Now, what could those EA nationals who were trying to come in for interview and were refused and detained, what could they have done differently? Well, they could have carried a letter with them in their hand luggage to show to border control. Now, ideally, this would come from the UK entity or the overseas employer. I do get people asking me to draft the letter from beginning to end, which I can do, but it's less weighty than something coming from an employer or the person inviting the person or the entity inviting the business visitor in. And this should set out exactly what activities they intend to undertake and how they fall under the permitted business activities. They should also carry the evidence of their ability to maintain and accommodate themselves. So bank statements or pay slips, and show that their hotel reservations already made and paid for, or whatever the accommodation arrangements are, that those have already been arranged. And then how are they going to show that they intend to leave within 6 months? Well, they're going to have a return or onward travel ticket for a departure from the UK within 6 months. Okay. Great. Charlotte, do you want to talk about the criteria a bit?
Yeah, absolutely. This links quite nicely back into the question we just had, really, about criteria of meeting the STBV and not meeting the STBV, and also links back into another question we had earlier in the webinar as well about branches of UK companies. So for STBVs who don't meet the criteria, so we've talked a bit about STBVs who do meet the criteria. So that is employed by an overseas entity, you are resident overseas in a country that we have a double tax treaty with, and you are coming to the UK for a short-term project less than 183 days, and you're spending less than 183 days in the UK. So thinking about STBVs who don't meet the criteria. So if you are employed by a foreign branch of the UK company, you would not meet the criteria because that is considered to be a UK company, and therefore you don't come under the criteria to meet the relaxation of PAYE. If you don't come from a tax treaty country, so if we don't have a tax treaty with a country that individual is resident in, also you wouldn't meet that criteria either. And then the last point is the costs being recharged to the UK. So we are, as I referred to earlier, I don't want to get too technical because it gets quite technical and a bit complicated, but we are really looking at the employment income article in the treaty to see if those conditions are met. And one of those conditions is costs being recharged over to the UK. Now, there is a little kind of tweak in the STBV agreement where if you are spending less than 60 days in the UK, then in some circumstances, if your costs are recharged, you can still be covered. So that does make it a little bit more complex. That's why I put in brackets, depending on the number of days. For people coming on short-term projects, I think generally the costs wouldn't be recharged. But if they are, there may be a bit of a get-out clause, depending on how many days that individual has spent here. And I think that's probably when you're really getting some advice from a tax advisor at that point to really consider, because it can get a bit complex to do with costs being recharged, who is your economic employer, who is benefiting from the work. And I won't go into that now, but that's probably something you'd want to start getting advice on if it was getting a bit more complex in that situation. So if these STBVs don't meet the criteria, then you can sign up for what's called an annual PAYE scheme, otherwise known as an Appendix 8. And if those individuals have spent 60 workdays or less in the UK, you can agree with HMRC that you will operate PAYE at the end of the year. So you would put your RTI through in month 12, rather than having to do it on a monthly basis. So the advantage of that is that you can obviously see at the end of the year, is any tax due ultimately? You've got one process at the end of the year rather than on a monthly basis. So that does make it a little bit easier, but you still do have that administrative kind of burden, I guess, at the end of the year to make sure that you are filing this RTI for those individuals. And then in a lot of circumstances, and I can't really comment specifically on this because I'm a UK advisor, but you would generally then be looking at claiming a credit in the overseas country so that you're not doubly taxed in both the UK and the overseas country. So that is what would happen for STBVs who don't meet the criteria. Just seeing a question in the chat about gross up. So yes, that would be if you are equalising those individuals, but if you're not equalising them, then you wouldn't need to gross up. So I think what you're saying there sounds like it's correct. If you've decided to equalise those individuals, then you would gross up, but otherwise, no, you would just report as per normal.
Okay, great. Thanks, Charlotte. Did you want to say anything else about this topic?
No, I think that's pretty much all I've got to say on STBVs who don't meet criteria. I think we now might be into non-resident directors, which I'll move on to.
I think I'm going to talk about different types of visitors first, and then we'll do non-resident.
Oh, yeah.
Okay.
Yeah.
So I'm just going to backtrack a bit because I've been talking about visitors, but I should let you know that some people are able to travel to the UK and gain entry as visitors at the border. They're called non-visa nationals. Other people have to apply for their visas beforehand, their visit visas beforehand. Those are visa nationals. There are also situations where non-visa nationals should apply for a visit visa in advance of traveling. And that would be, for example, if they have been refused previously, any type of visa to the UK, particularly visit visas, or if they're applying for if they want a long-term visit visa or particular types of visitor visas. So just wanted to set out the difference between visa and non-visa nationals there, and then talk a little bit about the types of visitor visas, or at least one of the types that would be relevant for businesses, and that's permitted paid engagement. So this is a non-standard visitor visa type. So I mentioned that there was standard visitors under which the permitted business activities can be undertaken. But if you're getting a permitted paid engagement visitor status, then that's a different type of visitor visa, in fact. And permitted paid engagement visitors can be paid from within the UK. So you remember that generally standard visitors cannot be paid from within the UK. Permitted paid engagement visitors can be, but only for up to 1 month. And it's only for certain roles or sectors. So the people have to be experts in their fields. They have to be doing the same thing in the UK that they do overseas. And it's specifically for certain academics, litigators, so lawyers, and then some creatives, artists, entertainers, sports people, and fashion models. The way fashion models operate doesn't really fit very well within the rules, and they can come in under permitted paid engagement. So I've just mentioned that here, but as I said, there are lots of exceptions, and the visitor rules, although they underwent a simplification a few years ago, there really is a lot in there, and there's a lot in there to be taken advantage of. So they're worth looking at if what you want to do doesn't fall exactly within the permitted business activities. But, if ultimately you can't come in as a visitor, you are going to have to get a work visa for that person. So people who are making applications for visitor visas before coming to the UK can apply for 2, 5, or 10-year visitor visas. So they're not reapplying every time. And the fees differ and start at £95 for, I think, the 6-month one. Okay, so now we're going to talk about consequences, actually. Would PPE, permitted paid engagement, apply to consultants? Yes, permitted paid engagement could apply to consultants, Jordana. Thanks for your question. Okay. So let's talk about the consequences of illegal working. Consequences. Dun, dun, dun. So there are a number of criminal penalties. Now, the Home Office has said all over its new prevention of illegal working code of practice, all over its new guide for employers to on right to work checks, they've kind of said, oh, don't worry, we're not really going to impose criminal penalties on you. They're just there. So they set them out and then they say, oh, but don't worry. So don't trust the Home Office. They can pull this out whenever they want ultimately. And indeed, the independent chief inspector of borders and immigration, when they reviewed immigration enforcement, advised the Home Office to use some of these criminal penalties more often to elicit a better deterrent effect than the civil penalties alone. So what are the criminal penalties? Up to 5 years in prison, an unlimited fine, premises closure. This is one that a lot of people don't know about. So an immigration officer can come to your premises, your business premises, and order them closed for up to 48 hours. Within that time period, they go to a judge. The judge can close it for up to a year. As I said, this power in particular is one that the independent chief inspector of borders and immigration has recommended that immigration enforcement increase the use of. Also, if you have a sponsor license, if your company has a sponsor license, it can be revoked and all your sponsored workers would have to leave or find a new sponsor within 60 days or another visa type. If you don't have a sponsor license yet, then you might be ineligible to apply for one for some time. There are civil penalties that could apply of up to £20,000 per illegal worker. So those really add up. And they are another recommendation by the Independent Chief Inspector of Borders and Immigration is for immigration enforcement to widen the scope of their enforcement activities to focus less just on ethnic restaurants and more on, other sectors in the economy. So that they haven't had a chance to kind of implement that yet because of COVID, but now that things are picking up again, maybe they will. And also the names of the companies who were liable for fees are published on gov.uk. And for some companies, this is actually the worst consequence because it's the effect on your brand and reputation. And the amount of the penalties are listed. And you'll see there that there are increasingly some businesses from different sectors of the economy. So, these consequences do happen. So do keep them in mind. And basically, if you come in as a business visitor and you're not abiding by the restrictions on work and on payment, types of payment, then you'd be considered to be working illegally. And that would trigger, that could possibly trigger these consequences. Okay. Charlotte?
Thank you. So moving on to consequences of not having an agreement or consequences of not tracking your individuals and reporting appropriately. So I think this slide probably speaks for itself, but if HMRC do find out that you aren't tracking your individuals, you don't have an agreement when you should have, or you're not reporting PAYE when you should do, this can lead to an actual PAYE audit. So then HMRC would start to look at other things within your business. So they might come in and start looking at travel expenses, for example, or they might come in and start looking at reporting of share schemes, all sorts of things they could come in and start to audit. If you've also not reported PAYE when you should have done, you've obviously got the risk of penalties and also interest as well, which can rack up if into quite a significant amount of money. As Samara just talked about as well, I think one of the big things at the moment is reputational damage. It's your brand in the marketplace, and I think that's what lots of companies are concerned about. They don't want their name to be associated with not reporting. It's become such an ethical issue. It also can result in enhanced scrutiny from HMRC. Once they've picked up one thing, they will start to look at other things, and you don't really want that enhanced scrutiny and kind of stress of them looking over everything. They do have a special team to look at these areas, so that's something to bear in mind. And also just to mention the Senior Accounting Officer and Corporate Criminal Offence legislation. It is really important that this is becoming a big issue that HMRC will take seriously and they will follow up on. And I think another really important point to mention is, although the tracking does seem quite onerous, it's not accepted by HMRC as a reason for non-compliance. So you can't turn around and say to them, well, we've got so many business visitors with so many different businesses, we just can't track them. It's just impossible. They're not going to accept that at all, especially as there are obviously technological ways that you can track now. There are lots of things out there to help you track. They will be looking for that process that you've got in place. Can you explain to them how you're tracking? Can you, clearly outline what your process is for following your STBVs? So definitely something we would recommend to put in place if you haven't done already.
Okay, great. I'll just note that, I'm aware we're coming up on an hour, so I think we are going to take the 1.5 hours, or come close to taking the 1.5 hours allocated for this webinar. If people do need to leave on the hour, just be aware we will be sending out a link to the recording of the webinar. But there is a fun bit that we have left to the end on remote and stranded workers, which I think will be interesting. So if you can stay for that, please do. So Charlotte's going to now talk about non-resident directors, which I know she was keen to do for you guys.
So yeah, thanks, Samar. So as I talked about a little bit earlier, non-resident directors are sometimes treated differently. You do need to consider what role your non-resident directors are undertaking when they're in the UK. So, for example, you might have an individual who is a non-resident director of the UK company, but also has a global role. And when that individual comes over to the UK, what are they actually doing here? If they're doing global role duties, then that would normally be under the scope of the STBV, assuming they met all the other conditions that we've already talked about. But if they're coming over here to actually perform director duties, then generally that is not under the scope of the STBV. That is actually considered an office holder in the UK and would need to be reportable through payroll. So the income that would relate to the duties they're performing here, and again, you're probably looking at the proration like we were talking about earlier, you would be putting that through the UK payroll. Some individuals may have a separate contract for their director role, in which case you might have already carved out a certain amount, specified amount that relates to their director duties, and that would go through the UK payroll. If you're in an instance where that person's got one contract for everything, one total remuneration for everything, then HMRC won't take the kind of excuse that, they're not being paid for those director duties, everything they're being paid for relates to their global role duties. If they come to do director duties in the UK, HMRC will say, well, a portion of their remuneration, however many days they've spent over their total work days, would normally be the way of looking at it. That relates to their direct duties and should be reportable. And in those instances, you might then be looking at applying for what's called a Section 690 directive, which is a directive that taxes a portion of their income based on their director duties. So it can get a bit complex with non-resident directors, because I think companies aren't always fully aware of what those individuals are coming to the UK to do. And you might get to the point in time where your advisor is asking you those questions for the reporting, and you might not have even considered it at that point in time, and you've got to kind of scrabble back, look back, what were they doing? And really that should have been thought about up front so that the correct amount can be put through the payroll. So that's something really important to think about. I'm not going to go into the next bit in much detail because I'm not a corporate tax advisor, but if you've got a non-resident director who is performing a lot of their director duties for the UK company overseas, then you may possibly need to look at the corporate implications, because has that residence of the company moved based on the director, and it would come down to lots of factors. How many directors have you got, where are they performing duties? And obviously, because of COVID as well, there's been a lot of relaxation on those kind of rules. But going forward, as we kind of move out of COVID, that's something else to consider as well. So yeah, just a few points to think about with relation to STBVs and non-resident directors.
Great tips, Charlotte. Okay, this is what I think a lot of people will be thinking about now. Remote workers, stranded workers, the effects of COVID-19, COVID-19 concessions. So let's talk a bit about that, and do let us have your questions.
Thanks, Samar. Yeah, absolutely. I mean, I think when the pandemic hit, kind of, March 2020, working in global mobility tax, you start to think, well, we're not going to have many people moving. What's our workload going to be looking like? But actually, it kind of took off because we had a lot of clients coming to us saying, we've got someone who, for example, is on a UK employment contract. They're a Spanish national, but they've lived in the UK for the last 5 years. They've been working for us on a UK contract. But actually, when the pandemic came along in March last year, they decided, not staying in the UK, I'm going to head back to Spain to be with my family. And they've been working remotely in Spain for the last, 6 months, a year, et cetera, and I think companies were in quite, some companies were in the kind of place where they had quite a good handle on where their workers were. Some companies really didn't find out for quite a long time, the kind of covert remote workers who had moved without telling any of their managers and just were working remotely without anyone knowing. So this has been a really hot topic over the last kind of year and a half. As we kind of start to slowly come out of COVID, we're probably looking less at stranded workers, although there are definitely still people around that are struggling with border closures. But we're seeing now a lot of companies coming to us and saying, well, actually this has worked really well for us for the last year. We can start hiring remotely now because, talent, for us, talent is really important. So actually, we've got someone that lives in Germany. We want to employ them through the UK company. They're going to be living in Germany, working in Germany for the majority of the time. They might come over to the UK for a few work days here and there, but essentially spending a lot of time in Germany. And this does create a lot of questions, because you've got to start thinking about not only what are the tax consequences in the UK if they're doing some of their duties in the UK, if they are performing a lot of their duties overseas and they are resident overseas. As an employer, do you then have an obligation? Do you have an obligation to withhold tax? Do you have an obligation to withhold social security? And the other really big question as well is, depending on what that person is doing and their job role and responsibilities, are they potentially creating a permanent establishment for the UK company in that overseas country? So these are the kind of questions we've been seeing a lot of, and I think it's not going to go away. I think it's actually going to get bigger, because companies are starting to realize that, they can recruit from anywhere. We are seeing varying opinions depending on a company's culture, because obviously, some companies are very hot on talent attraction and retention. To them, that is the most important thing. So, although they want to make sure that they fulfill all their tax obligations, they don't kind of mind if there's an extra tax administration burden, because for them, talent is really important. Other companies, possibly the tax risk is a bit more important, and they don't want to kind of start recruiting from here, there, and anywhere, because that's going to create issues they don't really want to get into. So it really does depend on the company and the company's culture and what their priorities are. And I think just on that point as well, if you are in this position as a company, make sure you've got all your stakeholders on board, because you may find that HR is on a very different page to the tax department, for example, and you've kind of got to work out between yourselves where that kind of bottom line is. And then just thinking about going back to tracking again, tracking of remote workers has become a really big issue as well, because if you've got someone in an overseas country and they've spent a certain amount of time there, as I've just mentioned, you could be creating, all sorts of obligations that you need to be aware of. And again, there are now apps and online technological solutions that you can use to track, one of which we do have at BDO called BDO Quick Trip. So if anyone's got those kind of questions, then yeah, do reach out. It's definitely, unfortunately, in this scenario, it's kind of not really, again, a one size fits all, because each person's situation can be very different. However, there are definitely policies that you can put in place within the company, and there are kind of decision trees that you might want to implement within a company to decide, if someone comes to you and says, I want to work remotely, you can use that decision tree to work down what your risks are and whether you're going to allow that.
Nice. Thank you, Charlotte. So I'm going to talk a bit about COVID and remote and stranded workers in the immigration context. So in terms of sponsored workers, there is a concession that employers don't have to report when sponsored workers are working from home. So usually you would have to report a change in job location, and you don't if it's because of COVID. But if they are working from home overseas, it is still best practice to report that. You could probably get away with not doing so, but I would recommend that you do report that if they're working from overseas. There are COVID concessions for the days absent from the UK in terms of the limits on the days you're allowed to be absent from the UK if you want to be eligible for settlement. So the COVID concessions for that relate specifically to travel disruption. So the best type of documentation that the person will have when they get to the settlement stage would be things like canceled flights, documentation of canceled flights, documentation of closed airports, more general official government guidance on travel restrictions, that type of thing. Now, obviously, that's all a lot easier to gather now than it will be in 3, 4, 5 years' time when the person comes to apply for settlement. So something that employers can do now to help people who are working remotely from overseas and whose absences might otherwise exceed the limits relevant for settlement is to help them gather the requisite documentation. And when we're talking about settlement, we are talking about 180 days in any 12-month period. For sponsored for skilled workers, that's a 5-year period. So 180 days in any 12-month period within those 5 years. There are some variations on that depending on the date of the grant of leave. But otherwise, it's a rolling 12-month period. So it is actually quite easy to exceed the limits on absences, and you might need to take advantage of these concessions for absences that were caused by travel disruption due to the pandemic. Now, there's also a concession allowing sponsors to continue to sponsor workers who are absent from work without pay for 4 weeks or longer. Normally, you would have to terminate sponsorship in that situation, but because of the furlough scheme, et cetera, the government recognizes that some skilled workers might be absent for 4 weeks or longer, exceptionally due to the pandemic, and they're allowing that at the moment without having to terminate. Also overstaying, so let's say somebody was stuck here between 24th of January 2020 and 31st of August 2020, so kind of the first wave in the UK, will be disregarded. So those are some useful concessions and tips that I thought I should let you know about. Let's talk though a bit more specifically about business visitors, because what can happen is that you had somebody working in the UK, they've gone to work remotely from their country of origin, and now they need to come back to the UK to do a few things. You know, now that things are opening up, they need to come back in. So you're going to need to decide, are they coming in for a business visit or are they going to be working? You know, if their visa has expired, then, or, you know, their sponsorship is otherwise terminated and they're coming in to work, that is, do something outside of the permitted business activities, then you're going to have to apply for a visa for them. They can't just come in as a business visitor just because they used to work here necessarily. Now, you know, there are lots of options, lots of things we can do. You know, EEA nationals in particular, the concession for them to apply to the scheme, the COVID concessions for them changed, you know, within days of the deadline to apply for the scheme. So if somebody didn't get to apply, but they were overseas because of COVID and they're an EEA national, it's worth checking whether they might still be able to apply. There are some circumstances where you can make a late application, and that way they'd be able to secure some status in the UK and not have to enter as a business visitor or apply for a work visa, and they'd still be able to work here. If you do have people who are still stranded here, and as Charlotte said, this is less common now as restrictions lift in in several places, but not all, you can apply for something, or they can apply for something called exceptional assurance. It's not quite a visa, it's not quite leave, but it's this assurance that the government's not going to penalize you. You do have to apply for it, and you can do so if your visa is expiring before the 31st of September now. They've kept extending the visa expiry deadline for people who can take advantage of it. For a long time, there were switching provisions, allowing people to switch from within the UK to routes that they would normally have to apply for from overseas. Those have sadly come to an end. And so, maybe people were preparing applications to be able to use those from within the UK. There might be something we can do through prior authorization, agreeing prior authorization from the Home Office, but that general concession allowing switching has ended. So I would say, the main point in relation to business visitors and remote or stranded workers, I hope you can hear me. As soon as I said the main point, I got this message that my internet connection is unstable. But the main point in relation to business visitors and people who've been working remotely is that they might now have to be coming in, applying for a work visa, even if they are coming in as business visitors and their activities fall within the permitted activities. Do look into giving them a letter. I can provide a template for that. Let's say somebody's going to be coming in a lot over the next few years and they're always doing the same thing. We can work on a letter together that they can use every time. Or if you have a lot of different people always coming in for the same reason, we could give you a template for that. So do give them what they need for smooth entry to the UK if they're coming in as business visitors. It has changed. We've been shielded from Brexit by COVID, basically. But now that COVID restrictions are lifting, people are feeling the effects of Brexit more. And Charlotte and I have talked a lot about this. So do be aware, travel is different now for a lot of reasons. Just be prepared. So that's all we had for you today. Thank you so much for coming. Those are our details, and we will follow up with a link to a recording. As I said, does anybody, I'll just give people a chance to ask any more questions that there might be.
Yeah, I think just my kind of parting piece of advice, Samar, would be, the STBV agreement on the surface of it does seem quite straightforward, and making the agreement, can be, but as you may have kind of realized throughout the webinar, there are so many kind of twists and turns to the conditions. So, I think a lot of us, a lot of people do know the 183-day threshold. So, if you're in the UK for 183 days or less and you fulfill certain conditions, but there are all sorts of other things to consider about, where is that person resident, where are the costs borne, etc., etc. So I would say yes, probably, if you think you might be in a position where you do need advice on this, I would recommend you reach out and get some advice to check that you are kind of following everything properly.
Yeah, I think it's the same in immigration and tax. There are opportunities to be had, but you need to know where the hard stop is, don't you, as well?
Yeah, absolutely.
So please do get in touch with us if you have specific questions. As I said, our details are there and we'll be following up by email. Thank you so much, everybody, for joining. And thank you so much for your wonderful engagement. We really appreciate it. And take care. I hope everybody has a safe and happy summer. Thank you.
Thanks, everyone.